Okay, they asked me to just kind of give a year in review type situation. It's December, so these are the items that I'm going to cover today, but I'm going to be going pretty fast. My goal here is not necessarily make you feel like this, but you may feel like I'm just dousing you with a fire hose. But I wanted to at least alert you to some of the primary healthcare legal issues that that you should be aware of to this year that's gone on this year, and as we enter into the new year. Little disclaimer, everything I'm going to say may change because we have a new administration that will probably take us, a sharp turn to the right. In the past, when President Trump came in the first time around, he made a lot of changes to some of the regulations that existed before him. So we'll have to continue to watch that and see if it changes some of the things we're talking about today. In addition, we've got a pretty active Supreme Court that's been more willing than past Supreme Courts to vacate longstanding judicial precedent, like Roe v. Wade. So we'll have to watch all of those issues. I'm going to be going through this stuff relatively fast, as I mentioned, but I think almost everything that I'm covering today, I've written an article on it that you can access for free at our blog. So you can just go to our website there and you can get content on this type of stuff. With that said, the first thing is the minor consent law. You guys are probably familiar with this now. They really changed the way you have to do business in Idaho for healthcare providers, effective July 1st. You have to obtain parental consent to treat unemancipated minors with very limited exceptions. You've got to allow the parents to access the unemancipated minors' records with, again, very limited exceptions. If you fail to do that, then the parents can go ahead and sue you and recover their damages, costs, and attorney's fees. So, under the new statute, it states that an individual shall not furnish healthcare service to a minor child without obtaining the prior consent of the minor child's parent. A couple of comments here. Note that it applies to not just healthcare providers, but any individual. I mean, theoretically, it could apply to a grade school teacher that wants to put a Band-Aid on a kid's knee. It's very broad. It applies to any healthcare service, which is any service for the diagnosis, screening, examination, prevention, treatment, cure, care, or relief of any physical or mental healthcare condition, injury, illness, defect, or disease. Note that it's not just those providers with a direct treatment relationship, but it could also apply to, radiologists or labs. They're rendering healthcare services and they've got to have consent, but they don't ever have that direct communication or direct contact with the patient. That makes it a bit problematic for them. It applies to a minor child. A minor child is defined as an unemancipated person who's under 18. If they're emancipated, then this law does not apply. But if they're unemancipated, then this new statute does apply. Of course, in Idaho, the emancipating events we think are if they are married or have ever been married, if they are serving in the active military, perhaps if they are on their own and self-supporting, but that's a little bit fuzzy. It requires the consent of the parent. Parent is defined as the biological or adoptive parent of an individual who has been granted exclusive right and authority over the welfare of a child under state law. Under the prior law, if the parent wasn't available, you could get consent from, a grandparent or somebody else. This new statute does not allow that. It just says that you got to get the consent from the parent. The parent is the one with exclusive right, because a grandparent or a step parent or a foster parent, they don't have exclusive right, then they don't necessarily fit within the definition of a parent, and they wouldn't be able to give effective consent. If you violate it, again, the parents may sue for damages. Well, that raises the question, what about all those laws that were on the books that allows the minors to consent to their own health care? For example, if they're sufficiently mature in Idaho, they could have, and they wanted contraceptives, they could go ahead and get contraceptives, age 14 for communicable diseases, admission to a mental health care facility, things like that. Are they still good? Are they still on the books? Well, the law is not entirely clear, but I'll be honest with you. I think the conservative approach and a fair reading of the statute is no, this was intended to trump all those prior laws. And so the other laws go away. Now you're just stuck with this statute. I know that there's some people who disagree with that. They may have a different take on that. But when you look at the legislative purpose that accompanied the new act, it states that the act is intended to supersede any current provisions of Idaho law that may otherwise conflict with the act. The statute itself says that the section shall be construed in favor of a broad protection of the parent's fundamental right to make decisions concerning the furnishing of healthcare services to minor children for those reasons, unless and until we get a contrary court decision or the legislature modifies the statute. I think you've got to assume that those other prior statutes go away. Now, there are some exceptions. If, of course, if the minor is emancipated, it doesn't apply. If you've got a court order that authorizes the treatment, then you're okay. There's an exception that would allow a healthcare provider may authorize or furnish the healthcare service without obtaining the informed consent of the minor child's parent if you have a blanket consent. What is a blanket consent? Well, we really don't know. The statute doesn't define that, but presumably it would be a consent that they give in advance that says, hey, yeah, you can go ahead and provide care for my child, even if I don't have all the information. You're not required to get informed consent, which is kind of curious, but there we go. If you are going to rely on that blanket consent, then I think be careful. You're going to want to make sure whatever services you provide to the patient are within the scope of what that parent probably contemplated. If you're going to be involved in any kind of controversial or expensive or excessive care, I wouldn't rely on the blanket consent. I'd give specific informed consent. There's also exceptions for emergencies, but these emergencies are pretty extreme, right? Death or imminent or irreparable physical injury, or life or health would be seriously endangered. That's probably not going to come up in all that many cases. Now, what about federal law? There are certain federal laws like EMTALA that would allow minors to consent to their own health care, at least to initiate emergency screening. I think those still are probably valid. Title 10, if the healthcare service, the family planning services are funded by Title 10, then federal regulations would allow the minor to go ahead and consent to their own health care. But there was a Texas decision from the Fifth Circuit that said that no, that the regulations do not trump prior state law. So we don't know exactly. That case is still going through the appeals court. We don't know how that would apply necessarily in Idaho. So be careful in those situations. All right, that's a quick summary of the consent law. The other aspect of that law is the parents have a right to access their minor records, the minor child's records. Now, remember, the way the law was before is if the parent has authority or the person has authority to make healthcare decisions for the minor, then they're the personal representative and they have a right to access those records. On the other hand, if the minor could consent to their own healthcare, then the parent is not the personal representative for purposes of HIPAA, and you generally need either a HIPAA exception or the minor's consent to go ahead and make those disclosures to the parent. Idaho also had some specific statutes that would allow you to withhold information from the parents. In the wake of this new law, though, I think that those contrary statutes go away. Not necessarily HIPAA, but the Idaho state statutes. So under the new law, it states that no healthcare provider or government entity shall deny a minor's child's parent access to health information that is in such healthcare provider's control. Now, health information is very broad. It's not only your medical records, but it's any information about the minor child that they can get. Note that it is not just records that were created after this new law took effect on July 1st. It's any information. So even if you created the records under a promise of confidentiality as the law existed before July 1st, I think that probably the parents now have an obligation or a right to access that information. If you don't provide it to them, then you can get sued under the new statute. There are some exceptions. Again, if the minor is emancipated, you don't need to worry about it. If the parent's access to the requested information is prohibited by a court order, then you don't need to do it, but that's not going to happen very much. If the parent is subject of an investigation related to a crime committed against the child and a law enforcement officer requests that the information not be released, then you don't have to. But note, this is different than the law was under HIPAA, right? Under HIPAA, there is an exception. If you don't think it's in the child's best interest, you think it's an abuse situation, then you could withhold it. But this Idaho statute is more narrowly tailored. It only applies if there's an ongoing investigation and a police officer tells you not to disclose it. Well, what about HIPAA? Does the new law preempt HIPAA? Well, HIPAA generally defers to state law when it comes to parental access. However, there is a provision under HIPAA that says, notwithstanding the state law or any requirement of this subparagraph to the contrary, a covered entity may elect not to treat the person as the personal representative, meaning you don't have to disclose it to the parent, if the covered entity has a reasonable belief that the individual has been subjected to abuse, or treating the person as the personal rep could endanger the individual, and the covered entity in the exercise of professional judgment decides that it's not in the best interest of the individual to treat the individual as the personal rep. I think that this probably still controls. I think HIPAA probably preempts the Idaho law. But, we don't know. We'll have to wait and see how that shakes out. There are other limited exceptions for substance use disorder records, but that's very limited. There's also the federal Title X program regulations, but as I mentioned, that's been challenged in the Fifth Circuit. We'll have to see how that plays out. All right, that is a very quick recap. If you want more information about that, I've published several articles on it, including some FAQs. You can just type in my name or Holland and Hart, Idaho minor consent law, and you can access it that way or shoot me an email. All right, let's talk a quick update about Idaho abortion laws. They're on the books, right? It's generally a total abortion ban. There are a couple of exceptions to that, including the EMTALA exception. Remember, the federal district court originally said that EMTALA preempts the Idaho total abortion ban if it's an EMTALA case at a hospital. That was then overturned by the Fifth Circuit. It went up to the Supreme Court. The Supreme Court originally ended that injunction, but then they reconsidered and put the injunction back in place. So currently that injunction is still in effect. So currently, Idaho cannot enforce that total abortion ban in EMTALA cases, but again, we'll have to watch and see how that plays out in the courts. Just this past week, we got a court decision concerning Idaho's abortion trafficking statute. As you may know, that abortion trafficking statute generally prohibits anybody from encouraging, harboring, transporting a pregnant minor for an abortion without a parent's consent. That went up to federal court. The federal court just issued a decision in which they allowed Idaho said Idaho could actually enforce that, except for provisions that prohibit communication about abortion. You can't necessarily prohibit that because that would affect free speech. So that abortion law is on the books. I'm not overly concerned about that because it only the abortion statute as an affirmative defense. If you get parental consent, then you don't need to worry about it. So, and the statute itself is only triggered if you try to encourage or secure an abortion without parental consent or without the notice of the parent. So the bottom line there is make sure that if you are going to recommend or facilitate an abortion, make sure you get parental consent. All right, let's talk quickly about fraud and abuse laws like the False Claims Act, the Anti-Kickback Statute, Stark, etc. No major changes in any of that other than the penalties have gone up a little bit. But there are a couple of important things to remember. Remember, under the False Claims Act, you can't submit a false claim to the government, but it not only applies to affirmatively submitting those false claims to the government, but also if you submitted a claim when you shouldn't have, like you've submitted a claim in violation of Stark or the Anti-Kickback Statute, or you didn't comply with the Medicare billing rules. Well, in that situation, you've got an affirmative obligation to report and repay. And if you don't, then you can get hit up with penalties. In addition, you can be subject to a qui tam litigation, which is when a third party comes in and sues you on behalf of the government for these false claims. The government, in a case out of Florida, for the first time that I'm aware of, the court in that particular case raised questions about the constitutionality of a qui tam litigation. They actually said that the qui tam statute is unconstitutional. So we'll have to see how that plays out. More important for you guys is the government issued a new rule that applies to your obligation to report and repay. Remember, under the False Claims Act, if you discover that you've been paid improperly, then you've got an affirmative obligation to report and repay the federal government within the later of 60 days after the cost report is due if you're paid on a cost report basis, or when you discover that there was that overpayment, okay? A couple of weeks ago, as part of the 2024 physician fee schedule amendments, they issued a new rule which basically modified that 60-day reporting period to shorten the window for doing the report and repayment. So if you do have a report and repayment situation, you've got to be careful and be aware of the new rule that sets deadlines for that. All right, let's talk about HIPAA and patient privacy. There are a couple of new deals about HIPAA. One of the most important ones is you look at the recent settlements that have come out of HIPAA, and the main HIPAA risks these days are cyber attacks and security rule violations. That is the big ticket item. It used to be that if you were hacked, if you were subject to a ransomware attack, the government took pity on you and they didn't bring HIPAA claims against you. Those days are over. When you look at the big ticket items, the big HIPAA settlements that have come out, almost all of them are related to cyber attacks or security rule violations. So you need to make sure that you're staying on top of those security rule issues. The third one that the government's active on is the right of access. They've got a right of access initiative that if you're not providing access to the patient or to the patient's personal representatives as required by HIPAA, then the government will come after you for those things. The government also issued their new reproductive health rule. This new reproductive health rule takes effect on December 23rd, 2024, so just a few weeks. Essentially, this new rule gives extra protections to reproductive health care records. Reproductive health care is interpreted broadly. It's any health care that affects the health of an individual in all matters relating to the reproductive system and to its functions and processes. The government was concerned in the wake of overturn of Roe v. Wade that you might have a situation, for example, here in Idaho, where we've got a total abortion ban. What happens if a patient goes across the state over to Oregon to get an abortion? What about if a prosecutor in Idaho wants to prosecute that patient or that patient's parents or that patient's provider for this abortion that occurred out of state? Well, the government, in the wake of Roe v. Wade, they can't just directly stop that, but the Biden administration said, okay, well, we are going to limit the disclosure of reproductive health care in situations if that reproductive health care was legal where it was rendered, then covered entities may not disclose reproductive health care protected health information for purposes of criminal, civil, or administrative liability or investigation. So the way that this plays out is if you have reproductive health care, whether you records, whether you provided the reproductive health care or not, if you've got records concerning reproductive health care and somebody shows up wanting those records and they want those records for purposes of criminal, civil, or administrative liability or investigation, so maybe it's a subpoena, maybe it's a request from a prosecutor, it's for one of those requests for purposes of criminal, civil, or administrative liability or investigation, you cannot disclose that information to that entity if the reproductive health care was legal in the area, in the location where it was received. So if, for example, you're here in Idaho, you've got reproductive health care information that when an Idaho citizen, we know, cross over to Oregon, got reproductive health care over in Oregon, you've got their records, but you get an Idaho prosecutor who wants those records. HIPAA says you cannot turn that information over to them if it was that reproductive health care was legal where it was rendered. And by the way, unless you've got reason to believe otherwise, the healthcare was presumed to be legal. Now, how do you know whether or not they're seeking information for purposes of criminal, civil, or administrative liability? Well, under the new rule, you've got to obtain an attestation from the person seeking that reproductive health care. So when they show up seeking reproductive health care for these purposes, you have to have them sign an attestation. That attestation has to contain certain elements. You can create your own, or better yet, you can go to the government's website and they've got a model attestation that you can use. Now, the scope of this isn't huge, right? It only applies if you get the request for information seeking it for purposes of the criminal, civil, or administrative liability. But in those situations, you're going to have to get this attestation before you can go ahead and turn it over. If the attestation states that, yes, we are seeking it for these purposes, then you can't give it. If the attestation says no, then you could probably rely on that unless for some reason the attestation is defective or you think the person's lying. Now, that reproductive rights rule is being challenged currently in Texas. We'll see how that plays out. It may be that the rule is gutted and it goes away, but in the meantime, you're supposed to comply with that new rule effective December 24th. One of the side effects of that new reproductive health rule is they modified the HIPAA rules for disclosures pursuant to law enforcement requests. Under the HIPAA rule, it would allow you to make disclosures for administrative requests, including administrative subpoena, summons, or the like, or authorized investigative demand. And so you'd have prosecutors who may show up and just say, hey, I want this information. I don't have a subpoena. I don't have a warrant, but it's an administrative demand. And they would try to buffalo you into providing the information. Fortunately, the government came out and cleared that no, just because a prosecutor wants it doesn't mean that they get it. You only have to provide that if that request requires a response under the law. So if it's a civil investigatory demand, there's some statute or law that requires you to respond, then in that situation, that would be a HIPAA exception, but just simply them showing up and requesting it is not enough. All right, there's also the new HIPAA concerns about online tracking technologies. There were several cases that came out where people found out that hospitals were selling information to Google, or Google was, Meta was implanting tracking devices in the hospital's website, and then they were using that information, and the OCR concluded that, hey, that raises HIPAA concerns because that data tracking information includes individual identifiable information, including URLs, email addresses. That's identifiable information. And if that's related to health information, then that's protected by HIPAA, and you can't use or disclose that information except as allowed by HIPAA. So they issued guidance concerning the use of these online tracking technologies. So if you are using online tracking technologies like cookies, web beacons, tracking pixels, a lot of other things that I don't understand, you need to be aware of the HIPAA implications on those types of things. You can't use those to get or disclose that information, nor can you allow your vendors or business associates to use that for purposes that are not permitted by HIPAA. So you may want to go back and check with your vendor agreements, make sure with your IT people that you're not using that tracking data improperly. There was a lawsuit brought challenging that. As a result of that, the government winnowed back the scope of that HIPAA guidance. So now just simply if you're tracking, traffic to your website, then that's probably not going to be protected because anybody could go there, right? It doesn't have to be a patient. On the other hand, if you're tracking information after a patient is logged into you've got an authorization from the patient, they've logged into behind a wall where only patients can log in, then at that point, that tracking technology stuff might apply. You not only have to worry about HIPAA in these cases, that's kind of a market industry out now. There's some law firms that are going around suing people, suing healthcare providers, hospitals, and the like that are violating these rules by using this tracking technology. So be careful about that. In other HIPAA news, in 2021, the government proposed new rules under HIPAA, and we are still waiting for those rules. We think that they'll probably issue this next year because of some stuff that's come down the pipe, but we're going to have to wait to see exactly what those new rules say, but just be aware of what they may entail. If they follow the proposed rules, it will strengthen the individual's right to access information. It will allow them to come in and take photos with their camera phone of their health records, maybe to avoid paying. It can put additional limits on your ability to charge for records. It will require some changes to the notice of privacy practices and things like that in just a little that I'll talk about in a minute. All right. Also in privacy news, the government issued new regulations governing substance use disorder programs. So if you are a federally assisted substance use disorder program, then you got to comply with Part 2, 42 CFR Part 2, in addition to HIPAA. Not only that, but if you are a recipient of records that were created by a federally assisted substance use disorder program, then you also have to comply with Part 2. Now, that created a lot of problems for people. And the government tried to ease that a little bit by basically coordinating the Part 2 rules, amending the Part 2 rules so they more closely align with HIPAA. If you are a Part 2 program, I'm not going to go through it in any detail today, but make sure you're aware of those new rules. I've done some articles and I did a presentation on that. You can access it on our website. If you are not a Part 2 program, but you receive Part 2 information, just realize that you've got to comply with Part 2. You will know that because those records should be accompanied by a notice that says that, hey, this is covered by Part 2. The good news, however, for you as a recipient of that information, as long as you're covered by HIPAA and you comply with HIPAA with regard to those records, then you generally are deemed to comply with Part 2. That was the whole purpose, or a major purpose, of these new Part 2 regulations. Both HIPAA and these SUD regulations are going to require you to make changes to your notice of privacy practices. That's that document that you have to post in your office or your facility, and you also have to put it on your website that explains the notice of privacy practices. You're going to have to make changes to accommodate the new reproductive health rule as well as the new SUD rule. However, the government has given you until February 2026 to make those changes. The reason that they're pushing that out so long is they're going to require additional changes as part of the proposed HIPAA rules, and they want to issue those new rules, so you only have to amend your notice once. So just be aware that's coming down the pipe, but I would not worry about making those amendments this next year. Data security. I mentioned data security is a big issue for HIPAA. More importantly, it's just a big issue to survive in healthcare these days. When you look at the number of hacking incidents over the years, I mean, it's just skyrocketing. Healthcare providers, you guys are a prime target for the bad guys, the cyber attacks, because your data is so critical. They know you're going to have to pay the ransom, or a lot of you will pay the ransom in order to get your data back because of the consequences of a cyber attack. I mean, how can you provide effective care if you don't have your records? It's a life and death situation for the patient. Because of that, you are a major target for cybersecurity breaches. Just if you question that, just remember the Change Healthcare, how that affected it. I'm sure all of you have been affected by the Change Healthcare. Just a word about that. That was a breach. So that means that you guys have an obligation to notify your patients about that breach, but the government has said that you can delegate that to Change to do those breaches. You're now past the deadline, so hopefully you already did that. But if you have questions about the healthcare cybersecurity breach or what your obligations are, you can go to this website and it will explain to you what the obligations are for cybersecurity breaches and your obligations under that the Change cybersecurity breach. The government is extremely concerned about cybersecurity in the context of healthcare. Back in 2023, about a year ago, December, well, almost exactly a year ago, HHS published its strategy for strengthening cybersecurity. And they've told you, right, that this is coming down the pipe, including cybersecurity requirements for hospitals through Medicare and Medicaid. And they're going to update the HIPAA security rule to include new cybersecurity rule requirements. So expect that to come out before too long, probably this next year. They're going to increase the civil penalties for cybersecurity violations, and they're going to increase its audits for and investigations for cybersecurity situations. The government, as I mentioned, cybersecurity, it's a huge issue when it comes to HIPAA now. So you need to really make sure you're complying with the security rule, not only for HIPAA, but just your safety. That means doing your periodic assessment and working with your IT people to make sure that your data is secure, consistent with the HIPAA standards. The government has given you a bunch of resources on how to comply with this. If you haven't given this to your IT people, make sure that they're aware of it. You can go to this cybersecurity gateway that the government has established, and at that gateway, they've got a wealth of resources that will help you comply with cybersecurity issues. The government has proposed, that's working its way through Congress now, a new statute that would implement the administration's guidance that they send out. This new statute is the Health Infrastructure Security and Accountability Act, or HISA, to go along with HIPAA. It would provide mandatory cybersecurity standards for healthcare providers, require you to get annual independent cybersecurity audits. It would also allow HHS security audits. It would require top executives in your organization to certify compliance annually and could subject them to liability if they fail to certify appropriately. It could eliminate statutory caps on HHS fines for cybersecurity violations. So it could be a significant change. Well, it's a bipartisan act. It's got a lot of momentum. We'll have to see whether it passes, but just be aware of those things. Note that the FTC is getting into this, not just the Office for Civil Rights. The FTC is now using the False Claims Act, the Federal Trade Commission Act, Section 5, to go after entities for data security breaches. This is the statute that prohibits unfair and deceptive trade practices. The government's saying, hey, if you represent to your patients that you're using this information or keeping their information confidential and you're not, then hey, that's a violation of Section 5. Or if you simply are not putting in place security measures to protect it, then you could be violation of this statute and could be subject to a bunch of penalties. Just a list of those recent cases that have come down where the government's using the FTC to go after you. The bottom line there is there's a lot of regulatory reasons why you need to take cybersecurity very seriously, but infinitely more important than the regulatory requirements are simply the requirements for business. I mean, how are you going to continue to operate your business if you have a cybersecurity attack and you can't access your information? The cost of responding to a cyber attack, I think that the median cost is about $11 million. So you have to make sure that you do the investment to maintain appropriate cybersecurity. All right. Let's switch from talking about securing that information to sharing that information under the information blocking rule. As you know, the information blocking rule came out a couple of years ago. It applies to healthcare providers as well as developers of health IT and the like. It prohibits information blocking. That is a practice that is likely to interfere with access, exchange, or use of electronic health information if you're a provider, if you know that that practice is unreasonable, or if you're a software developer, if you knew or should have known that it's unreasonable. So if HIPAA allows you to make that disclosure, or the law allows you to make that disclosure of electronic records, then the information blocking rule says you can't put in place unreasonable safeguards to prohibit that disclosure of the information. The theory there is that free flow of information makes the provision of healthcare cheaper and more efficient, and the government wants to make sure that that's not slowed down. Now, you haven't had to worry about that to date, because even though developers of software developers and the like, they were subject to $1 million fine, there was no rule issued against providers, but that has changed. The final rule was issued in June of 2024. So now if you are a healthcare provider and you violate the information blocking rule, you could lose federal funding through different federal programs. Particularly for you as providers, you could lose your status as a meaningful user under MIPS, and so you could use that MIPS subsidy. You could lose that MIPS subsidy. All right, next one is the Telephone Consumer Protection Act. The Telephone Consumer Protection Act is the statute that prohibits the use of robocalls, automatic phone dialing systems, or texting to, it's the type of thing that you get on your text that you hate, right? Those things. Generally, you can't use those without the patient's consent. Now, there wasn't an exception for certain healthcare messages that you as a healthcare provider could send certain messages without the patient's consent, but the definition of healthcare message is really limited. It's basically those messages that are specific to providing healthcare, like appointment reminders, things like that. It is not marketing. It is not billing or collections. It is not that type of stuff. So if you're using robocalls, you need to be concerned about the Telephone Consumer Protection Act. You can get hit with all sorts of penalties if you violate that. Now, even if you're using it for the healthcare messages, those permissible healthcare messages that you don't need prior consent, the statute was amended a little while ago, or the regulations, so that you can only limit those healthcare messages to 1 call per day up to 3 calls per week. For everything else, the government has said they issued new regulations that take effect in May. So if you're using robocalls, robotexting for non-healthcare messages, then you've got to put in place these processes to allow the patient to opt out of that or stop or revoke that, and make it a lot easier for them to get out of it. Let's talk about AI. AI is everywhere out there. I'm not going to go into a lot of depth. Just be aware that there's a lot of focus on AI in healthcare, about the concerns, about what the some of the problems might be. Is it really giving you good results? Is it garbage in, garbage out? There's concern about the lack of transparency in the algorithms. Is it really giving you good results through how is it coming up with the results that it gives you? Does it implicate data privacy? Are there concerns about bias or discrimination? Because you put in data and maybe the data is biased, and it could result in bias against persons with disabilities or persons who are subject of a particular race or the like. Because of this, there's a lot of concerns about AI. The law is trying to catch up with the technology. There's a lot of federal as well as some states passing laws or trying to pass laws for AI. We haven't got a lot of those on the books, but that will probably be coming out in the next little bit. So watch for the AI concerns. In the meantime, probably the main concern you have is if you're using AI, it's now appears to be becoming standard that you should probably get consent from the patient. If you're using, for example, AI to help you take notes, generate your medical record, those types of things, you may have an obligation to obtain the patient's consent about using that AI, but we'll have to see how that shakes out. All right, let's talk briefly about telehealth. Remember, telehealth exploded in COVID, partly because CMS and Medicare, they relaxed the rules associated with telehealth and allowed you to get paid for a lot of telehealth visits that you couldn't have been paid for before. After the COVID pandemic ended, the government gave you time to transition away from those COVID waivers just remember that a lot of those COVID waivers now are set to expire on December 31st, 2024. So if you are engaging in telehealth, you need to make sure that after December 31st, 2024, you are complying with the rules, particularly with regard to Medicare payments, so that you can continue to get paid for telehealth. Just realize those rules are changing, so make sure that you're complying with that. Beware of states, not only the states where you're located, but the states where the patients are located, because they will have their own telehealth rules that you'll need to comply with. Now, one of the rules that came out was generally under the federal Ryan White Act, it required you to have an in-person visit before you could prescribe controlled substances through the internet or basically through telehealth. During COVID, they extended the to allow you to do that through a telehealth visit. Those have been extended now. I think we just got the word that they're extending it yet again. So that's still going to allow you to do that for a while, but just make sure that you're complying with all the regulations concerning those issues. The next items I wanted to talk about were the non-discrimination rules. Biden administration is, that was a big emphasis for them this past year. There are a bunch of anti-discrimination laws on the book, including the Affordable Care Act, Section 1557. This actually was passed during the first Biden administration, or excuse me, the Obama administration. President Trump, in his first administration, he ratcheted those back. President Biden put him back on the books or beefed him back up. So now, effective July 5th, we've got the updated 1557 rules concerning discrimination. In addition, effective July 8th, we've also got new rules governing disability discrimination. Essentially, those rules, you got to be concerned about how you treat persons with disabilities, persons with limited English proficiency. The 1557 applies to sex discrimination. Both rules apply to physical access to facilities and equipment. They will also apply to accessibility on your websites and your mobile apps, and of course apply to service animals. By the way, service animals are only dogs and mini horses. It's not emotional support animals. The rules really haven't changed with regard to service animals, but nevertheless, these are rules that apply there. In general, when you're talking about these laws, they apply most frequently in the cases of disabilities or persons with limited English proficiency. In the case of disabilities, you've got to provide reasonable accommodations to ensure that you can have effective communications and accessibility for those persons so that they can access the equipment and the services. You've got to provide auxiliary aids, and you've got to modify your policies or processes so you're not discriminating against persons with disabilities. Disabilities are interpreted very broadly. It basically includes anything that could adversely impact the normal activities of daily living. It could be obesity, could be mental health care problems, it could be pretty much anything out there. Your obligation to accommodate or provide auxiliary aids includes not only the patient, but also persons who accompany the companion of the patient, like a spouse or a significant other. Even if the patient doesn't have a problem, if you need to accommodate that person, then the rules require you to do that. You can't charge the patient for those costs. That's just considered a cost of doing business. You may not rely on the person accompanying the patient to provide the services or interpreters or things like that. When it comes to limited English proficiency, you must provide meaningful access. Again, that generally means that you've got to provide an interpreter and you've got to translate key documents. Again, it includes not only the patient, but any companions with the patient. You may not charge the patient for those services. You may not require the patient to bring their own interpreter, and you may not rely on the person accompanying the patient to provide the interpreting services unless it's truly an emergency. Now, there are some additional requirements under the new 1557 rule that applies to discrimination on the basis of race, color, national origin, sex, age, and disability. The new rule has specific requirements for appointing a coordinator and a grievance procedure. If you have more than 15 employees, you've got to have policies and procedures adopting these new rules. They have revitalized. You're going to have to provide a notice of non-discrimination to your patients of the new rules. You're going to have to provide a notice of the availability of language assistance services. I'll talk more about these in just a minute. You're going to have to make sure that you provide equal access on the basis of sex, facility accessibility, so that persons can access your facility. Make sure your information and communication technology is accessible to these persons. And you've got to make sure that to the extent you're using patient care decision support tools, particularly AI, that it is not discriminatory against those individuals. Now, the new 1557 rules, the rules applied to sex. The Biden administration had taken the position that would include like gender identity, those types of things in a case that came out. In a couple of cases that came out, they said that it doesn't, that the federal courts in those cases barred application of the 1557 rule when it comes to gender identity, but we'll have to see how that plays out in the courts. In addition, remember that when President Trump was in the first time around, he kind of gutted a lot of the notice requirements under the 1557 rules. We don't know, but it's possible that he will gut those once again. So even though the Biden administration put in those notice requirements again, those may be going away. So we'll have to watch and see how that plays out. In the meantime, though, these are the deadlines. So by July 5th, it's already passed, you should be providing meaningful access to these persons. You're not discriminated on the basis of race, disability, national origin, and the like. By November 2nd, if you have 15 plus employees, you are supposed to have designated a 1557 coordinator, and you're also supposed to publish a notice of non-discrimination on your website in your physical location and upon request. That notice of discrimination is available on the government's website. I'll come to that in just a second. By May 1st of this next year, you've got to make sure that you don't discriminate in the use of those decision support tools to make sure that they're not discriminating against any of these persons. And you've got to train your employees concerning the new 1557 policies and procedures, and you've got to document that training. Now, curiously enough, even though you're supposed to train your employees by May 1st, by May 5th is when you have to actually implement your policies and procedures. I don't know why you have to train before you implement the policies and procedures, but there you go. In addition, by July 5th of 2025, unless the rules change, you're going to have to publish a notice of availability of services. That has to be published in English and at least the 15 most common languages consistent with the requirements of the rules. You can get those notices by going to the government's website here, dealing with the 1557 rules. It's got a bunch of resources, including a summary of the rule and those sample notices that you're going to have to give out. That's the 1557 rule. Separately, the government issued its new rules putting in place the disability, prohibiting disability discrimination. That's been on the books since 1974, but they finally got around to updating the regulations after 50 years. In addition to the stuff that has been on the books, like notice and signage requirements, communication, facility accessibility, service animals, those types of things, they've come up with new regulations that prohibit discrimination with regard to medical treatment. It basically, this regulation prohibits, well, remember in COVID that, you know, when there were crisis standards of care and some people were saying, well, this person's already sick, so we're going to reserve our ventilators for the people who aren't so sick. That you can't do that anymore. That's you probably couldn't do it then either. But under the new regulations, it prohibits any of those decision support tools, those decision making that devalues a patient's life just because they have a disability. There's new requirements concerning mobility devices, you know, walkers, the use of scooters, things like that. New requirements concerning medical diagnostic equipment I'm going to come to, the use of kiosks and web and mobile apps. The new deadlines take effect by July 8th. You can't discriminate. In addition, after July 8th, so now, if you purchased or renew a lease for medical diagnostic equipment, like an imaging center or something like that, like an MRI or other types of medical diagnostic equipment, you've got to make sure that medically diagnostic equipment meets accessibility standards that are published by the government's standards for accessible MDE. The way that it works is you've got to make sure that at least 10% of your medical diagnostic equipment meets those government standards. At least 10%, but no less than 1. Okay, so that rule is in effect right now. That applies if you purchase or renew a lease for your equipment. You're supposed to At least 10% of your medical diagnostic equipment is supposed to satisfy these new standards, but no less than at least one of your equipment. Now, by May of 2026, if you have 15 plus employees, you've got to ensure your web content and your mobile apps comply with the web content accessibility guidelines with certain limited exceptions. So you've got a year and a half, if you've got 15 plus employees, to make sure your web content satisfies the government standards for accessibility. By July 8th of 2026, again, over a year, you've got to have at least one exam table and a weight scale that must meet the standards for accessible MDE. So they give you some time to purchase that. By May of 2027, all recipients, not just, and recipients are those who participate in any HSS program, all recipients must ensure their web content and mobile apps comply with the web accessibility guidelines. All right, so those are the deadlines that you're going to have to satisfy under the new Rehab Act rule unless the new administration changes those. Well, what's the penalty if you don't? Well, historically, basically the government comes in, slaps your hands, and makes you engage in additional training. They don't necessarily impose penalties, but that doesn't mean you couldn't get hit up with penalties. It's possible you could, or you could get sued by patients. So you got to take it seriously. All right. The government last year published new compliance program guidance. The program guidance from the OIG is not mandatory, but if you do put in place an effective compliance program, then the government theoretically will take it easier on you if you do have a violation. They just updated that last November. They issued the general compliance program guidance. It provides, if you haven't looked at that, you'd ought to. It identifies some of the key compliance risk areas, provides the elements for an effective compliance plan, at least by the government standards, and provide you some additional technical guidance. That was the general compliance program. The government's working on industry-specific guidance. We haven't got the ones for physician practices or the healthcare industry specifically. We did just get the new compliance guidance for long-term care facilities that came out. So if you haven't looked at those guidance, you should call up and take a look at those. A couple of employment law issues to wrap up. In the healthcare industry, it's kind of common for healthcare entities to hire people as contractors instead of employees. They sometimes do that to avoid having to do withholdings of taxes. Sometimes the employee wants to be a contractor instead so that they get a tax benefit from operating as an independent contractor. And so a lot of healthcare entities have played pretty fast and loose with the employer versus contractor distinction. Be aware of the risks have increased on that. If you are misclassifying a contractor who's really an employee, they walk like an employee, they quack like an employee, then they're an employee. Then if you misclassify them, you could be liable for tax consequences if you fail to do withholding or that employee fails to pay taxes. In addition, under the DOJ standards, they could come in there and perhaps claim overtime and things like that they might otherwise not be able to get. The DOJ just updated their guidance concerning the difference between an employee versus a contractor. So just be aware of those standards so that you consider that under the new DOL standards as well as the IRS standards. And you can access those at those sites on the screen. In addition, as you probably heard, the FTC, effective July or September, supposed to go into effect. They essentially outlined most non-competition, most non-compete clauses. That FTC rule was stayed by a federal court. We'll have to see how that shakes out. It's still going through the court system. So the prior FTC rule that prohibited those is currently stayed. So you can still use non-competes. My advice is you should have non-competes if you're an employer and you think that you ever might want to enforce that. Of course, in Idaho, you've got to make sure that your non-compete satisfies the standards in Idaho Code 44-2701. But that at least for the time being, those non-competes are enforceable or presumptively enforceable if you qualify under or you satisfy the standards under Idaho law. So you can ignore those federal rules for a while. Idaho Patient Act, remember that's still out there. That's that statute that requires you to give that the final notice and the consolidated statement and submit the CLIP bills to the in a timely manner to the insurers before you initiate extraordinary collection actions against the patient. Well, the problem was extraordinary collection actions include liens, and you had to do all this other stuff before you could file the lien. But the lien statute, the Idaho lien statute, required you to file the lien within 90 days after the last date of treatment. And so there was this conflict between the Idaho lien statute and the Idaho Patient Act. The government this past year, the Idaho legislature fixed that. So it would allow you to go ahead and file a lien despite the Idaho Patient Act. So just wanted to call that to your attention. All right, I've gone through a whole bunch of stuff. If you need additional resources, as I mentioned, I've got a lot of free content on our website, including recorded webinars about a lot of these topics we talked about today. They go into more detail. We've got client alerts, white papers, and the like. I think we left about 8 minutes for questions. So Layla, I turn it back to you or the group to see whether or not you have any questions. I see that there's a couple up there in the chat feature, maybe. Maybe not. Okay, any other questions that you have out there? If not, or you don't want to ask your question right here, you can email me and I'll try to answer offline as I have time.